Hey guys, so this is part 2 of Constitutional Law 2, and as I said in the previous video, I'll be continuing where we left off, and now we'll be discussing sections 2, 3, and 4 of the Bill of Rights in this video. So what is section 2? It's the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures of whatever nature and for any purpose shall be inviolable, and no search warrant or warrant of arrest shall issue except upon probable cause to be determined personally by the judge after examination under oath or affirmation of the complainant and the witnesses he may produce, and particularly describing the place to be searched and the persons or things to be seized. Actually, nandito na sa provision lahat ng i-discuss natin. But to better expound on all of it, let's tackle them one by one. So Section 2 of Article 3 deals with tangibles. It embodies the castle doctrine, which is a man's house is his castle. A citizen enjoys the right against official intrusion and is master of all the surveys within the domain and privacy of his own home. So this provision applies as a restraint directed only against the government and its agencies tasked with the enforcement of the law. It does not protect citizens from unreasonable searches and seizures perpetrated by private individuals. So the right to privacy and the right against unreasonable searches and seizures, the rule here is that the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures of whatever nature and for any purpose shall be inviolable. So the purpose of the provision is to protect the privacy and sanctity of the person and the inviolability of his house and other possessions against arbitrary intrusion by the state officers. So the provision does not prohibit all searches and seizures. What it prohibits are those unreasonable. So yung unreasonable lang daw yung prohibit. Unreasonable searches and seizures. Not all searches and seizures are prohibited. Those which are reasonable are not forbidden. A reasonable search is not to be determined by any fixed formula, but is to be resolved according to the facts of each case. Also, it must first be established that there is a reasonable expectation of privacy. So, when are searches and seizures unreasonable? Searches and seizures are normally unreasonable unless authorized by a validly issued search warrant or warrant of arrest. We better remember these search warrants and warrants of arrest, very important. Thus, the fundamental protection given by the search and seizure clause is that between person and police must stand the protective authority of a magistrate clothed with power to issue or refuse to issue search warrants or warrants of arrest. So, alin to, yung courts, who are protected by this section. So all persons, including aliens. Juridical persons are also protected. So the Section 2 protects citizens from unreasonable searches and seizures perpetrated by private individuals. So no, the constitutional prescription against unlawful searches and seizures applies as a restraint directed only against the government and its agencies tasked with the enforcement of the law. Recourse against private individuals is an action for damages under the Civil Code. So who can invoke the right against unreasonable searches and seizures? So yung right na to is personal. It may only be invoked by the person whose right is invaded. Can the right against unreasonable searches and seizures be waived? Yes. The right may be waived expressly or impliedly. Any objection to the legality of the search warrant and the admissibility of the evidence obtained thereby was deemed waived when no objection was raised by the appellant during trial. For sure, the right to be secured from unreasonable searches and seizures, like any other right, can be waived, and the waiver may be expressly made or impliedly made. So Section 2, sabi nga, deals with intangible. Section 2, paragraph 1 deals with intangible. Section 2, paragraph 2 is the exclusionary rule. It embodies the doctrine of the fruit of the poisonous tree. It will be discussed later. So, ito na nga, yung exclusionary rule. It is evidence obtained in violation of Section 2, Article 3, and shall be inadmissible for any purpose in any proceeding. So, wala daw visa ito. Ito yung fruit of the poisonous tree doctrine. So, yung sinabi ko nga tandaan natin kanina, yung search warrant. What is a search warrant? A search warrant is an order in writing issued in the name of the people of the Philippines and signed by a judge or a justice of peace and directed to a peace officer, commanding him to search for personal property and bring it before the court. This is under Rule 126 of the Rules of Criminal Procedure, Section 1. So a search warrant may be issued for the search and seizure of personal property. It is subject to of the offense, stolen or embezzled, and other proceeds or fruits of the offense, used or intended to be used as the means of committing an offense. Ano naman yung arrest? So an arrest is the taking of a person into custody in order that he or she may be bound to answer for the commission of an offense. It is effected by an actual restraint of the person to be arrested by that person's voluntary submission to the custody of the one making the arrest. Neither the application of actual force, manual touching of the body, or physical restraint, nor a formal declaration of arrest is required. It is enough that there be an intention of the part of one of the parties to arrest the other, and that there be an intent on the part of the other to submit, under the belief and impression that the submission is necessary. So ano ba yung general rule? The general rule, only a judge may issue a warrant. Yung exception dito, orders of arrest may be issued by by administrative authorities, but only for the purpose of carrying out the final finding of a violation of a law. We now go to the requisites for valid warrant of arrest. So yung requisites daw is there must be an information filed by the prosecutor recommending the trial of the accused, existence of probable cause determined personally by the judge, particular description of the person sought to be arrested. Lahat ng to, itatakan natin isa-isa later. We first go dun sa valid warrantless arrest. Ano nga ba yung mga valid warrantless arrest? We have arrests in flagrante delicto, flagrante delicto, hot pursuit arrest, and arrest of escaped prisoners. Ano yung in flagrante delicto? Ito yung when in his presence, yung tao na gagawa ng arrest, the person to be arrested has committed, is actually committing, or attempting to commit an offense. Yung requisites nito is that the person to be arrested must execute an overt act. Kailangan may overt act indicating that he just committed, actually committing, or is committing an offense. Pangalawa, such overt act is done in the presence or within the view of the arresting officer. A person committing a continuing crime, such as yung crime of rebellion, this is a continuing crime, may be arrested without a warrant because he is actually committing a crime. So the arrest, therefore, need not to follow the usual procedure in the prosecution of offenses, which requires the determination by a judge of the existence of probable cause before the issuance of a judicial warrant of arrest and the granting of bail if the offense is available. Obviously, the absence of a judicial warrant is no legal impediment to arresting or capturing persons committing overt acts of violence against government forces or any other milder acts, but equally in the pursuance of the rebellious movement. The arrest or capture is thus implied by the exigencies of the situation that involves the very survival of society and its government and unduly constituted authorities. Ano naman yung hot pursuit arrest? So hot pursuit arrest is when an offense has in fact been committed and he has personal knowledge of facts indicating that the person to be arrested has committed it. Yung requisites nito, may kaka-commit lang nung offender ng offense, di ba? A crime must be in fact or actually have been committed first. That a crime has actually been committed is an essential precondition. It is not enough to suspect that a crime may have been committed. The fact of the commission of the offense must be undisputed. The obligation of an agent of authority to make an arrest by reason of a crime does not presuppose as a necessary requisite for the fulfillment thereof the indubitable existence of a crime. For the detention to be perfectly legal, it is sufficient that the agent or person in authority making the arrest has reasonably sufficient grounds to believe the existence of an act having the characteristics of a crime and that the same grounds exist to believe that the person sought to be detained participated therein. So yung pangalawang requisite naman dito sa hot pursuit arrest is that the arresting peace officer or private person has personal knowledge of facts indicating that the person to be arrested is the one who committed the offense. Ano ba itong sinasabi nating personal knowledge? It's actually what we call probable cause. Paulit-ulit itong discuss ni Attorney Bonglo kasi nga sobrang important na sobrang important factor na there is a probable cause. He even distinguished when the judge is determining probable cause and when the prosecutor is determining probable cause. Pag yung prosecutor daw kasi, it's to file an information. Yung sa judge naman, it's to issue the warrants. But he discussed that in his own discussion and lectures in class. So it has been ruled that personal knowledge of facts in arrest without warrant must be based upon probable cause, which means an actual belief or reasonable grounds of suspicion. Personal knowledge of facts can either be based on actual belief, reasonable grounds of suspicion. So hindi yung sinasabi rin ni attorney dito, hindi pwedeng hearsay lang. Kailangan may actual belief, may reasonable grounds. Hindi pwedeng hearsay lang na isa-suspect na because that person may be innocent. The grounds of suspicion are reasonable when, in the absence of actual belief of the arresting officers, the suspicion that the person to be arrested is probably guilty of committing the offense is based on actual facts, supported by circumstances sufficiently strong in themselves to create the probable cause of guilt of the person to be arrested, and coupled with good faith. Therefore, the requisites of reasonable grounds of suspicion are actual facts and circumstances constitutive of probable cause and good faith on the part of the arresting officer. So hindi porket mukhang gangster yon or may masama pala siyang loob doon na nakita niya nagloloko before, is pwede niya nang sabihin na yun yung gumawa ng krimen. There has to be probable cause. So what is the length of time allowed between the commission of the crime and the subsequent warrantless hot pursuit arrest? It depends on the circumstances, but it cannot be an appreciable amount of time. Yung in-explain naman ni attorney dito, for example, yung hinahabol ng arresting officer, nakaabot ng Baguio. Sabi ni attorney, it's still considered hot pursuit arrest as long as hindi niya tatantanan yung gusto niyang i-arrest na may probable cause yung ina-arrest niya hanggat hindi niya tinatantanan at yun talaga yung gumawa ng crime. It's still under hot pursuit arrest. So although yung we go now to the third one, or the arrest of escaped prisoners. So when a person to be arrested is a prisoner who has escaped from a penal establishment or place where he is serving final judgment, or temporarily confined while his case is pending, or has escaped while being transferred from one confinement to another. The rationale for this is for one of the duties of law enforcers is to arrest lawbreakers in order to place them in the hands of executive and judicial authorities upon whom devolves the duty to investigate the acts constituting the alleged violation of law and to prosecute and acute and secure the punishment therefore. An arrest is therefore in the nature of an administrative measure. The power to arrest without warrant is without limitation as long as the requirements of Section 5, Rule 113 are met. This rule is founded on an overwhelming public interest in peace and order in our communities. So, balik tayo dun sa hindi nga pwedeng hearsay. Reliable information alone is not sufficient to make a warrantless arrest. The long-standing rule in this jurisdiction is that reliable information alone is not sufficient to justify a warrantless arrest. The rule requires, in addition, that the accused perform some overt act that would indicate that he has committed, is actually committing, or is attempting to commit an offense. We find no cogent reason to depart from this well-established doctrine. As applied to in flagrante delicto arrest, it is settled that reliable information alone, absent any overt act indicative of a felonious enterprise in the presence and within view of the arresting officers, are not sufficient to constitute probable cause that would justify in flagrante delicto arrest. Yung in flagrante delicto naman talaga, ginagawa niya talaga yung offense. Or alam mong kakagawa lang niya ng offense. Pero hindi kung wari, for example, may nakita kang tao, tapos amoy marijuana, i-arrest mo na ba yung person na yun agad? There is no sufficient probable cause. So the general standard to execute a warrantless arrest is the existence of probable cause. Like I said a while ago, it's very important to remember probable cause. In ascertaining whether the arrest without warrant is conducted in accordance with the conditions set forth in Section 5, Rule 113, this court determines not whether the persons arrested are indeed guilty of committing the crime for which they are arrested, Not evidence of guilt, but probable cause is the reason that can validly compel the peace officers in the performance of their duties and in the interest of public order to conduct an arrest without warrant. The court should not expect of law enforcers more than what the law requires of them. Under the conditions set forth in Section 5, Rule 113, particularly paragraph B thereof, even if the arrested persons are later found to be innocent and acquitted, the arresting officers are not liable. But if they do not strictly comply with the said conditions, the arresting officers can be held liable for the crime of arbitrary detention for damages under Article 32 of the Civil Code or yung arbitrary detention 124 ba sa RPC. So yung sinabi ko na nga kanina, what are the requisites for a valid warrant of arrest? So yung unang nating na-mention is there must be an information filed by the prosecutor in court recommending the trial of the accused. Who determines the existence of probable cause? Like I said a while ago, yung diniscuss ni attorney, na minsan yung determine yung pag sa warrants, yung judge. So, pero sabi nga dito, the prosecutor first and then the judge. Thus, there are two stages of determination. So, yung executive determination of probable cause, the determination of probable cause by the prosecutor, like I mentioned a while ago, is different from that which is to be made by the judge. Yung sa prosecutor, di ba, it's to file for the information. Yung judge, it's for the warrant. Whether there is reasonable ground to believe that the accused is guilty of the offense charged and should be held for trial is what the prosecutor passes upon. Yun na nga, yung pag-file ng information, di ba? Sa judicial determination naman of probable cause, the judge on the other hand determines whether a warrant of arrest should be issued against the accused, whether there is a necessity for placing him under immediate custody in order not to frustrate the ends of justice. Thus, even if both should base their findings on one and the same proceeding or evidence, there should be no confusion as to their distinct objectives. Note that since their objectives are different, the judge cannot rely solely on the report of the prosecution in finding probable cause to justify the issuance of a warrant of arrest. Obviously and understandably, the contents of the prosecutor's report will support his own conclusion that there is reason to charge the accused of an offense and hold him for trial. However, the judge must decide independently. Hence, he must have supporting evidence other than that the prosecutor's bare report, upon which to legally sustain his own findings on the existence or non-existence of probable cause to issue an arrest order. So, paano ba nagde-determine yung prosecutor ng existence and probable cause? Through preliminary investigation or inquest proceedings as provided in the Rules of Criminal Procedure. Yung existence of probable cause determined na personally by the judge, ano ba yung context nito? Probable cause in arrest cases consists of facts and circumstances which would lead and reasonably discreet and a prudent man which would lead a reasonably discreet and prudent man to believe that an offense has been committed. Sorry for the wang has been committed by the person sought to be arrested. Other jurisdictions use the term man of reasonable caution or ordinarily prudent and cautious man, but these all mean the same, which is an average man on the street and not someone trained in the law like a judge or prosecutor. So yung parang average man, papaniwala mo na itong taong to, siya talaga yung nag-commit ng crime. Bear in mind that an average man weighs the facts and circumstances using common sense. The need to find probable cause is dictated by the Bill of Rights, which protects the right of the people to be secure in their persons against unreasonable searches and seizure. An arrest without probable cause is a violation of the privacy of persons. So, probable cause ulit tayo. It is a reasonable ground of presumption that a matter is or may be well-founded, such as state of facts in the mind of the prosecutor, as would lead a person of ordinary caution and prudence to believe. Ito na yung sinabi ko kanina, na the term does not mean actual and positive cause, nor does it import absolute certainty. It is merely based on opinion and reasonable belief. Thus, a finding of probable cause does not require an inquiry into whether there is sufficient evidence to procure conviction. It is enough that it is believed that the actor or omission complained of constitutes the offense charged. Precisely, there is a trial for the reception of evidence of the prosecution in support of the charge. So how should the judge determine the existence of probable cause? So kailangan daw personally niya i-evaluate yung report and the supporting documents submitted by the fiscal, and on the basis thereof, mag-i-issue siya ng warrant of arrest. If on such basis he finds no probable cause, he may disregard the fiscal's report and require the submission of supporting affidavits of witnesses. So yung judge ba, should we read this text literally? Na kailangan ba personally examine nung judge yung complainant and his witnesses? So it says here that no, it was not. It was proper to interpret Article 3, Section 2 to mean that the judge must personally examine the complainant and his witnesses in his determination of probable cause. It only means that it is the exclusive and personal responsibility of the issuing judge to satisfy himself of the existence of probable cause. What he is required to do is to personally evaluate the report and documents submitted by the fiscal regarding the existence of probable cause, and on the basis thereof, issue a warrant. If he finds no probable cause because of the fiscal report, he may disregard it and require the submission of supporting documents, as we said a while ago. In so doing, he is not required to personally examine the complainant and his witnesses. Sound policy dictates this procedure so as to not unduly burden judges with preliminary examinations and investigations so they could concentrate on deciding cases. And the third requisite is particular description of the person sought to be arrested. So yung our John Doe, alam niyo yung John Doe or si Juan de la Cruz, warrants prohibited, pinoprohibit ba to? So the answer is no. On John Doe warrants, this rule or principle does not prevent the issue and service of a warrant against a party whose name is unknown. In such case, the best description possible of the person to be arrested is to be given in the warrant. But it must be sufficient to indicate clearly on whom it is to be served by stating his occupation, his personal appearance and peculiarities, the place of his residence, or other circumstances by which he can be identified. So next naman is yung valid warrantless searches and seizures. We go now to the next part. So ano ba yung mga, we see on the screen yung mga valid warrantless searches and seizures. We discuss them one by one. First, we have express or implied waiver or consented warrantless search. Yung under here, right against unreasonable searches and seizures may be waived by consenting to an illegal search. Yung requisites niya, it must appear first that the right exists. May right na Second is that the person involved had knowledge, actual or constructive, of the existence of such right. And third, that said person had an actual intention to relinquish the right. Yung rationale under this is when one voluntarily submits to a search or consents to have it made on his person or premises, he is precluded from complaining thereof. The right to be secure from unreasonable search may, like every right, be waived, and such waiver may be made either expressly or impliedly. Whether consent to the search was in fact voluntary is a question of fact to be determined from the totality of all circumstances. Relevant to this determination are the following characteristics of the person giving consent and the environment in which it is given. So yung age ng defendant, whether the defendant was in a public or secluded location, whether the defendant objected to the search or passively looked on, the education and intelligence, etc. So maraming factors to be considered. It is the state that has the burden of proving by clear and positive testimony that the necessary consent was obtained and was freely and voluntarily given. A waiver against illegal search and cannot be made under undue influence. What we see here is pressure exerted by military authorities. So may case kasi who practically coerced the petitioner to sign the supposed waiver as a guarantee against a possible challenge later to the validity of the search they were conducting. Confronted with the armed presence of military and the presumptive authority of a judicial writ, the petitioner had no choice but to submit. This was not, as we held in a previous case, the manifestation merely of our traditional Filipino hospitality and respect for authority. Given the respective atmosphere of the Marcos regime, there was here, as we see it, an intimidation that the petitioner could not resist. So ito, hindi siya nag-waive ng right. Merong factors to be considered na under tayo ng martial law. Then, so ano naman yung presumption against presumption is against the waiver. The rule is that courts indulge every reasonable presumption against waiver of fundamental constitutional rights, and that we do not presume acquiescence in the loss of fundamental rights. So the accused is not to be presumed to have waived the unlawful search conducted on the occasion of his warrantless arrest simply because he failed to object. Kasi syempre, laging protected ang ating fundamental rights. So second, we have warrantless search incidental to lawful arrest. When a person is validly arrested, he may be searched for weapons or anything which may be used as proof of the commission of the offense. This must be done on his person or in the immediate place of arrest. This is recognized under the rules of court and by prevailing jurisprudence. So, yung requisites naman niya is the arrest must take place before the search and seizure. Arrest must be valid either with a warrant or without, but falls under the exceptions. And yung rationale under this valid warrantless search and seizures part is the need to disarm the suspect in order to search him into custody. The need to preserve evidence for later use at trial. The law requires that there must first be lawful arrest before a search can be made. The process cannot be reversed. Hindi pwedeng i-search muna siya tsaka may lawful arrest. So the search can only be made at the place where the person was arrested and covers weapons or anything that can be used as proof against him. The better and established rule is strict application of the exception provided for in Rule 126, Section 12, and that is to absolutely limit a warrantless search of a person who is lawfully arrested to his or her person at the time of an incident to his or her arrest, and to dangerous weapons or dangerous drugs or anything which may be used as proof of the commission of the offense. Such warrantless search obviously cannot be made in a place other than the place of the arrest. Third, we have search and seizure of evidence in plain view. So objects falling in plain view of an officer who has the right to be in possession to have that view are subject to seizures. So ano yung requisites nito? The law enforcement officer in search of the evidence has a prior justification for an intrusion or is in a position from which he can view a particular area. Kailangan daw talaga nasa view lang niya, hindi niya pwedeng hanapin. So the discovery of the evidence in plain view is inadvertent and not deliberate. Like I said, hindi niya pwedeng hanapin. Kailangan talaga kita lang siya through the sight. It is immediately apparent to the officer that the item he observes may be evidence of a crime, contraband, or otherwise subject to seizure. So, kumare, may lawful arrest tapos yung may murderer silang i-arrest. Tapos saktong-sakto katabi ng murderer yung shabu. Kasi nagsashabu pala yung murderer. So, yun yung sinasabi nating on plain view. Hindi niya pwedeng halungkatin yung gamit nitong i-arrest nilang murderer para lang may makita silang other dangerous stuff. So in summary, the law enforcement officer must lawfully make an initial intrusion on properly be in a position from which he can particularly view the area. In the course of such lawful intrusion, he came inadvertently across a piece of evidence incriminating the accused. The object must be open to eye and hands, visual and touch, and its discovery inadvertent. So fourth is search of a moving vehicle. Search without warrant can be made in a moving vehicle. Yung requisites nito, their vehicle must be moving, the existence of a probable cause justifying the search. And the rationale behind this is that the guarantee of freedom for unreasonable searches and seizures is construed as recognizing a necessary difference between a search of a dwelling house or other structure in respect of which a search warrant may readily be obtained and a search of a ship, motorboat, wagon, an automobile for contraband goods where it is not practicable to secure a warrant because the vehicle can quickly move and be out of the locality or the jurisdiction in which the warrant must be sought. So the rules governing search and seizure have over the years been steadily liberalized whenever a moving vehicle is the object of the search on the basis of practicality. This is so considering that before a warrant could be obtained, the place, things, and persons to be searched must be described to the satisfaction of the issuing judge, a requirement which borders on the impossible in the case of smuggling effected by the use of a moving vehicle that can transport contraband from one place to another with impunity. We might add that the warrantless search of a moving vehicle is justified. It's justified on the ground that it is not practicable to secure a warrant because the vehicle can quickly move out of the locality or the jurisdiction from one place to another. Search of a moving vehicle is highly regulated by the government. The vehicle's inherent mobility reduces expectation of privacy, especially when its transit in public thoroughfares furnishes a highly reasonable suspicion amounting to probable cause that the occupant committed a criminal activity. Yung pang-apat naman is custom search in the enforcement of custom laws. An individual deputized by the Commissioner of the Customs for the purpose of enforcing customs and tariff laws may validly search containers without a warrant if there is reasonable cause to suspect the presence of dubitable articles. Yung requisites nito, there must be made under the authority of the Commissioner of Customs, pursuant to authority of from custom laws, and the search must not be made in dwellings. Pangatlo, probable cause of existence of dutiable or prohibited articles. Thus, in the extraordinary events where warrant is not necessary to effect a valid search or seizure, or when the latter cannot be performed except without warrant, what constitutes a reasonable or unreasonable search or seizure becomes purely judicial in question, determinable upon the uniqueness of the circumstances involved, including the purpose of the search or seizure, the presence or absence of probable cause, the manner in which the search and seizure was made, the place or thing searched, and the character of the articles procured. The Tariff and Custom Code does not require said search warrant. The code authorizes persons having police authority under Section 2203 of the Tariff and Custom Code to enter, pass through, or search any land, enclosure, warehouse, store, or building not being in a dwelling house, and also to inspect, search, and examine any vessel or aircraft and any trunk, package, or envelope, or any person on board, or to stop and search and examine any vehicle, beast, or person suspected of holding or conveying any dutiable or prohibited article introduced into the Philippines contrary to law, without mentioning the need of a search warrant in said cases. But in the search of a dwelling house, the code provides that the dwelling house may be entered and searched only upon warrant issued by the judge or justice of peace. So next is stop and frisk. When there is a genuine reason for the police officer to believe that a certain person has illegal firearms or is carrying illegal drugs in his possession, while probable cause is not required to conduct a stop and frisk, it nevertheless holds that mere suspicion or a hunch will not validate a stop and frisk. So hindi pwedeng kutob lang niya. A genuine reason must exist in light of the police officer's experience and surrounding conditions to warrant the belief that the person's detained has weapons concealed about him. What is therefore essential is that a genuine reason must exist in light of the police officer's experience and surrounding conditions to warrant the belief that the person who manifests unusual, suspicious conduct has weapons or contraband concealed about him. So the rationale in this is the general interest of effective crime prevention and detection, which underlines the recognition that the police officer may, under appropriate circumstances and in an appropriate manner, approach a person for purposes of investigating possible criminal behavior even without probable cause. So, ayun. Philippine jurisprudence has already expanded the scope of stop and frisk doctrine by including not just weapons, but also the seizure of illegal drugs in the event of a stop and frisk. Next is search during exigent and emergency circumstances. When the exigent and emergency circumstances justify a search without warrant, there was a under the foregoing circumstance, it is considered of the opinion that yung instant case, yung may dinascuss kasi dun sa book, na it falls under one of the exceptions as to prohibit against a warrantless search. In the first place, yung military operatives there, taking into account the facts obtaining in the case, had reasonable ground to believe that a crime was being committed. There was consequently more than sufficient probable cause to warrant their action. So yun nga, in parang emergency times yun, tapos may police officer na sinearch yung on the time of an emergency, there was a crime being committed. So they searched this particular person. So sinabi naman doon, na valid nga daw yun. So visual search at checkpoints. I was very interested in this kasi it's very appropriate in our certain time kasi lalo na now, MECQ pa rin. Tapos may mga checkpoints minsan, and usually when you know you're not violating anything, but when you're driving, nakakailang lang na parang uy, may checkpoint ganyan. Although wala ka talagang anything ha, pero wala ako, I don't know. Or in my opinion, parang ganun yung feeling ko every time na may checkpoint. So nakinig talaga ako dito, and attorney was saying nga na yung requisites ng checkpoint, there has to be a point. Hindi daw pwede na parang yung mga loitering ng police, bigla ka na lang bigla ka na lang papatigilid tapos parang sabihin nila checkpoint. So dun ko na na kailangan daw there has to be a point. So wag naman tayo masyadong matakot sa kanila. Lol. Well, they are the protector of our of our community. So are police checkpoints prohibited? Do they violate the right against unreasonable searches? So the answer is no. Checkpoints are not illegal per se. Thus, under exceptional circumstances like kagaya ng COVID, ngayon, MCQ, yung chine-check, yung mga important din naman yung parang tinignan nila yung mask, yung face shield, yung sa mga motor, ganyan. Kasi ang daming, usually mga motor yung sinastop nila eh. Thus, under yung where the survival of organized government is on the balance or where the lives and safety of the people are in grave peril, checkpoints may be allowed and installed by the government, kagaya nga now, na COVID. Routine inspection and a few questions do not constitute unreasonable searches if the inspection becomes more thorough to the extent of becoming a search. This can be done when there is deemed to be probable cause. In the latter situation, it is justifiable as a warrantless search of a moving vehicle. So yung probable cause, sabi nga natin, these are facts and circumstances antecedent to the issuance of a warrant that are in themselves sufficient to induce a cautious man to rely upon them. Yung warrantless searches by checkpoints is not violative of the Constitution for as long as the vehicle is neither searched nor its occupants subjected to a body search. So, kailangan daw talaga visual search lang siya. So, kailangan tinitingnan ka lang ganyan. So, hindi sila pwede mangabag, ganyan. Visual lang. Not all checkpoints are illegal. Those that are warranted by exigency, sinabi na kanina, na they can be valid and are conducted in a way least intrusive to motorists are allowed. For admittedly, routine checkpoints do intrude to a certain extent on motorists' right to free passage without interruption. But it cannot be denied that, as a rule, it involves only a brief detention of travelers during which the vehicle's occupants are required to answer a brief question or two. Kagaya nga ng parang pag-cross natin ng borders because we're now in under MECQ. So parang yung ibang checkpoints nandun lang sa borders. For example, you're going out of Metro Manila, pupunta ka dito kasi sa ibang areas hindi naman na MECQ, GCQ na. So kailangan din talaga. It's not just for hindi lang naman nila trip yun na inutos lang ng gobyerno all of a sudden. It's because we're facing this pandemic and the circumstances surrounding this. So for as long as the vehicle is neither searched nor its occupant subjected to a body search and the inspection of the vehicle is limited to a visual search, remember, visual search, said routine checks cannot be regarded as violative of an individual's right against unreasonable search. In fact, these routine checks, when conducted in a fixed area, are even less intrusive. Should police checkpoints be announced? The answer is no. There is no need for checkpoints to be announced. Not only would it be impractical, it would also forewarn those who intend to violate the ban. Even so, badges of legitimacy of checkpoints may still be inferred from the fixed location and the regularized manner in which they are operated. So the other valid warrantless searches and seizures include inspection of buildings and other premises for the enforcement of fire, sanitary, and building regulations, and search of vessels and aircraft for violation of fishery, immigration, and custom laws. Ano naman yung exceptions? The exceptions that are strictly construed against the authorities. The right of a person to be secured against any unreasonable seizure of his body and any deprivation of his liberty is the most basic and fundamental one. A statute, rule, or situation which allows exceptions to the requirement of a warrant or of arrest or search warrant must perforce be strictly construed and their application limited only to cases specifically provided or allowed by law. By the way, this election ni attorney, he discussed two kinds of inspection. So merong routinary inspection, and there's extensive. So, pag extensive daw, dun daw parang kailangan na talaga ng probable cause. So, the general requisite of probable cause is still required, notwithstanding the availability of the exceptions. This is to meet the requirements of reasonableness. The fact that the authorities have had the ample time and opportunity to procure a search warrant is a defense. Kung may time naman pala na mag-procure siya ng search warrant, bakit hindi ginawa? Ano naman yung requisites for issuance of a search warrant? So first, there must be an application under oath. Nasa provision na rin ito or this affidavit, which must refer to the truth of the facts that are within the personal knowledge of the petitioner or his witnesses. In the determination of probable cause, the judge must personally examine in the form of searching questions and answers under oath or affirmation the complainant and the witnesses he may produce, existence of probable cause as determined personally by the judge. The warrant must be issued in relation to one specific offense, and the warrant must particularly describe the place to be searched and the persons or things to be seized. So kailangan, based on personal knowledge, must be from the personal knowledge of specific facts of the complaint or the witnesses he may produce. So yung kailangan specific siya, it must be in connection with one specific offense. Yung ano yung procedure dito? So it must be under oath or affirmation. Sabi nga ni attorney, under oath daw yung so help me God, yung dun daw sa mga naniniwala sa Diyos. Pag affirmation daw, parang I affirm all that my statements are true, ganyan. So kasi nga, if hindi, pag nag-lie ka sa court, diba, you're gonna be held liable for perjury. Must be determined personally by the judge after examination under oath or affirmation of the complainant or the witnesses he may produce. Yung personal examination, as we said a while ago, hindi naman kailangan talaga na personal itong gawin ng judge. Judge must personally examine the complaint and his own witnesses in the form of searching questions and answers. Yung particular description, the place to be searched, or the things to be seized. So does a John Doe warrant satisfy the requirement of particularity of description? So the answer is yes, provided that it contains a description personally such as will enable the officer to identify the accused. Sabi, yung ginawang example ni attorney here was, arestuhin mo kung itong si Peter Young. Nakatira siya sa Torre Lorenzo Tower 1, 3A, so third floor yung condo. Tapos apparently tatlo yung 3A na condo doon. Pero na-identify na isa lang yung Peter Young doon, yung kapitbahay niya, kasi maingay doon yung Peter Young. So sabi nga dito na valid nga daw yun kasi nga na-identify na siya talaga. So can a search warrant be partially valid? The answer is yes. The general description of most of the documents listed in the warrants does not render the entire warrant void. Insofar as the warrant authorized the search and seizure of unregistered delivery receipts and unregistered purchase and sales invoices, the warrants remain valid. The search warrant is severable, and those items not particularly described may be cut off without destroying the whole warrant. So kasi pwedeng iba lang yung items yung mga items na describe, yun yung isi-seize. No provision of law exists which requires that a warrant partially defective in specifying some items sought to be seized, yet particular with respect to the other items, should be nullified as a whole. A partially defective warrant remains valid as to the items specifically described in the warrant. A search warrant is severable. The items not sufficiently described may be cut off without destroying the whole warrant. So, yan po yung kind of a short introduction into Section 2, Article 3. So, we go now to Section 3, Article 3. So, eto naman, yung provision na to, it extends the scope of the right of privacy as expressed in Section 2. When the 1935 Constitution now was being formulated, the controlling doctrine was that the search and seizure clause did not prohibit non-trespassory wiretaps. So, parang sa Descendants of the Homicide. Chloe, yung crash landing on you, wiretapping. This was the doctrine established in the 1928 in the Olmsted versus the United States. So, ano ba yung sinasabi nila dito? The tangibles only rule was anchored on the text of the Fourth Amendment, which enumerates tangibles, house, person, papers, effects. The Olmsted doctrine has been overruled, and the new rule is now to place wiretapping with or without physical trespass under the ban of search and seizure clause. Ano ba yung scope nitong right to privacy of communication and correspondence? So, yung Section 3 na to, the right of communication and correspondence shall be inviolable except upon lawful order of the court or when public safety or order requires, otherwise as prescribed by law. And any evidence obtained in violation of this or the preceding section shall be inadmissible for any purpose in any proceedings. What are the forms of correspondence and communication covered in this provision? So it covers letters, messages, telephone calls, telegrams, and the like. So when is intrusion into the privacy of communication and correspondence allowed? It is allowed only in upon lawful order of the court and when public safety or order requires it as prescribed by law. Upon what grounds may the court allow intrusion? The text does not give any grounds, sabi ni Bernas. It is submitted that the requirement in the preceding section should be followed. Should the order also particularly describe the communication or correspondence sought to be seized? When the correspondence sought is written correspondence, it would seem that there should be no inconvenience in requiring particularity of description. But if the intrusion is to be done through wiretaps, how is the description to be made? Evidently, it would be impossible to describe the contents of a communication that has not been made. Hence, it would be unreasonable to require a description of the content of the communication. But the identity of the person or persons whose communication is to be intercepted and the identity of offenses sought to be prevented and the period of authorization given can be specified. So, in fact, an attempt in this direction is made in Section 3 of RA 4200 or the Anti-Wiretapping Law. So, ano ba yung RA 4200? So, ito yung law which provides penalties for specific violations of private communication. Section 3 of the Act allows court ng authorized taps under specific conditions for the crimes of treason, espionage, provoking war, disloyalty in case of war, piracy, mutiny in the high seas, rebellion, conspiracy and proposal to commit rebellion, inciting rebellion, sedition, conspiracy to commit sedition, inciting to sedition, kidnapping, crimes against the government. And what is the consequence of evidence obtained in violation of Section 3? So sabi nga, kahit naman Section 2, it is inadmissible. Section 3 expressly provides that any evidence obtained in violation of this or the preceding section shall be inadmissible for any purpose in the proceeding. So, walang visa po ito. So, we go now to Section 4. So, no law shall be passed abridging the freedom of speech or expression or of the press or the right of the people peaceably to assemble and petition the government for redress or grievances. So, freedom of expression is an alienable human right that flows from the very nature of man. It must be nurtured and protected by the state for the full and proper growth of the individual and the nation. Ano ba yung purpose? It is only free debate and free exchange of ideas that a government remains responsive to the will of the people and peaceful exchange. The press, as the fourth estate, scrutinizes the acts and conduct of public officials and the plans and policies of the government, holding the government accountable to the people. If we preserve this right, public opinion must be enlightened. Political vigilance must be encouraged. So, yung scope ng Section 4 daw is yung freedom of speech, expression, and of the press. And speech, expression, and press include every form of expression, whether oral, written, tape, or disc recorded. It also includes movies, as well as what is referred to as symbolic speech, such as the wearing of an armband by a symbol of protest. Peaceful picketing has also been included within the meaning of speech, conduct which remains to speech. Not all kinds of speech and expression are treated with the same degree of protection. So we have preferred speech, less preferred speech, and unprotected speech. Preferred speech is the doctrine on freedom of speech was formulated primarily for the protection of core speech or speech which communicates political, social, or religious ideas. These enjoy the same degree of protection. In less preferred speech, such as commercial speech, which does not enjoy the same level of protection as political, social, or religious expressions. And we have unprotected speech, such as libel or obscenity. So what is symbolic speech? This is when speech and non-speech elements are combined in the same course of conduct. In this case, a sufficiently important governmental interest in regulating the non-speech element can justify incidental limitations on free speech. And second, we have the right of the people peaceably to assemble and petition the government for redress or grievances. So what is public assembly? It means any rally, demonstration, march, parade, procession, or any other form of mass or concerted action held in a public place for the purpose of presenting a lawful cause or expressing an opinion to the general public or any particular issue, or protesting or influencing any state of affairs, whether political, economic, or social, or petitioning the government for redress or grievances. So, what is freedom from prior restraint or censorship? What is prior restraint? Prior restraint means official government restrictions on the press or other forms of expression. So it's in advance of actual public dissemination. The term prior restraint is used to describe administrative and judicial orders forbidding certain communications when issued in advance of the time that such communications do occur. It is basically censorship. So such as a system of licensing administered by an executive officer. So movie censorship, judicial prior restraint, which takes the form of an injunction against publication. So parang pinoprohibit niya. License taxes measured by gross receipts for the privilege of engaging in the business for advertising in any newspaper, or flat license fees for the privilege of selling religious books. Content-based laws amount to prior restraint. So what is freedom from prior restraint? Freedom from prior restraint is largely freedom from government censorship of publications, whatever the form of censorship, and regardless of whether it is wielded by the executive, legislative, or judicial branch of the government. So are all kinds of prior restraint prohibited? So no. Although any system of prior restraint comes to court bearing a heavy presumption against its constitutionality, there are exceptions to the rule. Freedom of expression is not absolute, since it is always subject to the police power of the state. This is premised on the need to protect society from the injurious exercise of said freedom and the need to promote public welfare, public safety, public morals, and national security. Yung exceptions naman ito, cases where prior restraint is permitted, in cases of pornography, false or misleading commercial statement, advocacy of imminent lawless action, danger to national security, press statement made by person for and on behalf of the government uttered while in the exercise of their official functions, movie, television, and radio broadcast censorship in view of the access to numerous people, including the youth, who must be insulated from the prejudicial effects of unprotected speech. It is not unconstitutional for Congress to grant administrative body quasi-judicial power to preview and classify TV programs and enforce its decision subject to revenue. Why are courts? So yung MTRCB, am I right? MTRCB, they regulate, right? Yung mga content-based films, kung pwede ba na sa live TV na lang. Live TV coverage may be prohibited since the right of the accused must prevail over the right of the public to information and freedom of the press. Pero hindi na rin masyado nasasunod to kasi a lot of people are going live in YouTube. So, common power under 9C4 to regulate time in broadcast media and space in the papers is an exception to the freedom of speech and press clause on account of considerations more paramount for the general welfare and public interest, which exceptions, after all, would operate only during limited periods, that is, during the campaign filed in the charter itself or by the law. The provision on freedom of expression must be read in the conjunction with the power given to the Commission on Elections to supervise and regulate media during elections, as well as with the various provisions in the Constitution which place a high premium of equalization of opportunities. Yung exceptions to the prohibition of prior restraint or censorship tests of valid or prior restraints. So, meron din tayong yung test nga, although prior restraints on speech are generally invalid, there are those which may be permitted under the Constitution if the restraint to be imposed meets the burden of proof necessary to uphold its validity. So, freedom from subsequent punishment, yung pangalawa. What is subsequent punishment? These are sanctions of penalties imposed by the government on conduct amounting to speech or expression after publication or dissemination. What is freedom from subsequent punishment? It is a limitation on the power of the state to impose a punishment after publication or dissemination. So kung kanina censorship, ito after. It is a prohibition on systems of subsequent punishment which have the effect of unduly curtailing expression. So the rationale for this is, for indeed, if prior restraint were all that the constitutional guarantee prohibited, and government could impose subsequent punishment without restraint, freedom of expression would be a mockery and a delusion. The mere prohibition of government interference before words are spoken or published would be an inadequate protection of the freedom of expression if the government could punish without restraint after publication. Unrestrained threat of subsequent punishment itself would operate as a very effective prior restraints. So are all kinds of subsequent punishment prohibited? So kagaya kanina, no. Similar to the rules on prior restraint, the freedom of speech and expression is not absolute. This is subject to the police power of the state. Kasi nga, police power is for the general welfare. What are the standards for allowable subsequent punishment of expression? So kagaya ng mga tests na na-discuss natin in the previous video, we have dangerous tendency test, we have clear and present danger test, then we have balancing of interest test. So parang we applied this to we have meron pa palang isa, sorry. I think the O'Brien test, yon. So, we applied these tests to freedom of expression. So, gano'n na nga, kung may dangerous tendency, clear and present danger, balancing of interest. So, sa balancing of interest, this test requires a court to take conscious and detailed consideration of the interplay of interests observed in a given situation. So, yung i-weigh mo yung different interests involved in the controversy. So, parang yung theory dito ng court, sinasabi na kung yung parang yung mini-measure dito, binabalance out kung yung right to freedom of expression or yung public policy, alin doon yung, or yung general welfare ng tao, alin doon yung mas kailangan bigyan ng weight. So a lot of tests are used in order to ascertain whether the right to freedom of speech is violated or may be practiced with the police power. So what is commercial speech? It is communication which no more than proposes a commercial transaction. It concerns only commercial or economic activities such as advertisement of goods or services. Does every form of speech enjoy the same degree of protection? Kagaya naman ng pag-differentiate natin kanina, no. The doctrine of freedom of speech was formulated primarily for the protection of core speech or speech which communicates political, social, or religious ideas. These enjoy the same degree of protection. Commercial speech, however, does not. So we have facial challenge of laws regulating freedom of speech and expression. A facial challenge is allowed to be made against vague or overboard laws unduly abridging freedom of speech and expression. This is because of the possible chilling effect upon protected speech. The theory is that when statutes regulate or prescribe speech and no readily apparent construction suggests itself as a vehicle for rehabilitating the statutes in a single prosecution, the transcendent value to all society of constitutionally protected expression is deemed to justify allowing attacks on overly broad statutes with no requirement that the person making the track demonstrate that his own conduct could not be regulated by a statute drawn with narrow specificity. So, on its face, invalidation of statutes has been described as manifestly strong medicine to be employed sparingly and only as a last resort, and is generally disfavored. So we know naman yung what is facial challenge, overbred doctrine. I think we learned this in our introduction to law. So I'm no longer gonna discuss this. So ano ba yung unprotected speech? There are certain well-defined and narrowly limited classes of speech, the prevention and punishment of which has never been thought to raise any constitutional problems. It has been well observed that such utterances are no essential part of any exposition of ideas and are such slight social values as a step to truth, and that may be derived from them is clearly outweighed by the social interest in order and morality. So yung unprotected speech, yung libel tsaka obscenity. Libel is punished under the revised penal code, I think article 353, 2362. Yun yung libel. See the revised penal code for it. So, kailangan daw sa libel may actual malice. Every defamatory imputation is presumed to be malicious, even if it be true, if no good intention and justifiable motive for making it shown. So, meron naman tayong tinatawag na where malice is not presumed. We have privileged communication, fair and true commentaries of governmental conduct, fair commentaries on matters of public interest, commentaries on public officials and public figures, and testimony in judicial proceedings which are relevant to the case. So, yun na nga, we have absolute privileged communications na kagaya na sinabi kanina, fair and true commentaries. Dito naman daw, presumed na wala malice. So, We have the test for obscenity also, the Miller test, and the corrupting tendency test. So yung mga taong out, there is a right of assembly. Historically, it is the primary right, the right to peaceable to assemble to a subordinate and instrumental right, as the provision read, the right of the people to peaceably to assemble in order to petition the government. So syempre may right naman tayo na mag-form ng assemblies. So when can the right of assembly and petition be impaired? Only when there is a clear and present danger of substantive evil. Can the right of assembly and petition be regulated? Yes, it is subject to the reasonable and regulations of the state. The state, through the proper LGU, may regulate the time, place, and manner of the assembly, and a prior permit is normally required. So, ayan na nga, na-discuss naman natin lahat ng nasa screen now. If you can read the books of Bernas and De Leon if hindi masyadong detailed yung pag-discuss ko dito sa last part because we haven't really tackled this topic yet. But we have a quiz on this tomorrow. Good luck me. So, ayun. Thank you for listening, and this was Constitutional Law 2. I'll be uploading more videos on our next topic in Constitutional Law 2 under the playlist Constitutional Law 2. Thanks for listening, and I hope this helped your review in Consti Law. Thanks!